Hello, America. I'm Mark Levin. This is Life, Liberty, and Levin. We have two great guests. Bradley Smith. How are you, my friend? Good to see you. Gregg Jarrett. Good to see you.
Good to see you.
Briefly, everybody knows who you guys are, but we're going to do this anyway, okay, just in case. You were commissioner at the Federal Election Commission starting in 2000. You were chairman at one point. You graduated from Harvard Law School, and you were confirmed to the FEC in 2000. Prior to your appointment, you were a professor of law at Capital University in Columbus, Ohio. You taught election law. Matter of fact, you spent your whole life studying, teaching, and around election law. Is that correct?
Yes.
Your writings on campaign finance, other election issues, and this is important that we get your background in here. They've appeared in the Yale Law Journal, the University of Pennsylvania Law Review, Georgetown Law Journal, the Harvard Journal of Legislation, Cornell Journal of Law and Public Policy, and other academic journals. You have founded the Institute for Free Speech, and you're a professor again at Capital University. Gregg Jarrett, you graduated from University of California Hastings College of Law in 1980. You worked as a defense attorney for several years in San Francisco. You taught law as an adjunct professor at New York Law School, and you lectured at other law schools. And you've written a fantastic New York Times bestseller, #1, The Russian Hoax, the illicit scheme to clear Hillary Clinton and frame Donald Trump. So I needed you gentlemen here for a reason. We're going to dig into some of what's going on. And I want to start with you, Brad Smith. People tell us federal election laws are arcane. They are arcane. There's too damn many of them. But that said, people want them. They keep demanding, less money in politics. So I want to ask you a question. If there's an individual who makes a payment from their own pocket or from their own company, or they direct their private lawyer to make a payment, whom they later reimburse, even if they don't reimburse, also from the same funds, to enter into a nondisclosure agreement with an individual, involving alleged activity that preceded this individual's candidacy for any federal office. Is that a campaign contribution?
The short answer there is no.
And why not?
Well, it's not because it doesn't arise out of the campaign. And the key thing that you said there, Mark, is that this happened before the campaign was going on, the events that give rise to it. And under the Federal Election Campaign Act, anything one spends to influence a campaign can be deemed to be a contribution or expenditure under one part of the law. But the law contains other clauses that focus on what are not campaign expenditures and what is called personal use. And you can't convert your campaign funds to personal use. So what the courts and what the statute says very clearly, what the FEC has said in its regulations, is if something is not an expense that arises directly out of the campaign, for example, you rent an office for campaign headquarters, you hire a campaign manager, you pay for TV ads, you print up buttons and bumper stickers. Those are all things you're doing because you're running for office. But the fact that something helps your campaign doesn't make it a campaign expense. For example, I decide I'd look better on the campaign trail if I had my teeth whitened. Not a campaign expense. I want a new suit to look good at a debate. Not a campaign expense. Or to take something that's more relevant to what we've seen going on recently, you allude to sort of the Trump payments to some of these women who alleged various affairs and so on. If I'm a successful businessman and I decide I want to run for office and I say, look, I've got all these lawsuits against me, as businessmen often do, against their companies and so on. These are all a bunch of BS, no merit to them, but I don't want them out there. I don't want people asking me about them. I don't want them dragging my campaign. Settle those lawsuits, I tell my lawyer. I can't pay those settlements with campaign funds. That's not a campaign expenditure. The obligation did not arise out of my running for office. So that's the long answer to your question. Short answer is the simple no. Paying somebody for something to be quiet about something that was done or alleged years before is not a campaign expense.
Greg, obviously I'm talking about the Southern District in New York and the Cohen case. And Cohen pleads.
Sure.
Two of the counts he pleads to are campaign violations.
Right.
You had media types running around saying, well, if he pled to a crime, that means that Donald Trump is an unindicted co-conspirator. Is that correct?
No, it turns criminal law on its head. It's upside down. First of all, he pled guilty to a non-crime. People actually do that all the time in a plea bargain agreement in which, the prosecutors say, you're going to spend the next 50 years behind bars, but if you plead to what we want you to plead to, we'll let you out in 2 or 3 years. You can have a life, see your kids and your wife. So people oftentimes will plead guilty to things they didn't do or non-crimes because that's what prosecutors want them to do. I've always objected to flipping witnesses and so forth under pressure because it's nothing more than bribery and extortion. In this particular case, I talked to 2 or 3 different election law experts, one of which spent most of his career at the Department of Justice doing election law, and he laughed and he said, Cohen pled guilty to 2 non-crimes. He said there's no possible way that what he did and what Trump did is criminal. So this is what prosecutors wanted. They wanted something in this plea deal that would implicate Donald Trump. And that, to me, is unconscionable and fundamentally wrong on the law.
And think of this, what kind of precedent this would set. The prosecution says it influenced the campaign, as you point out. There's 1,000 things that influence a campaign in a positive way. Maybe I want to buy a $5,000 suit with my own money. There's a lot of things. Maybe I want to buy an old used Chevy and trade in my brand new Cadillac so it looks better in the campaign. That positively influences the campaign. Let me ask you something. Members of Congress, we know this is a matter of fact, settled ethics complaints involving sexual harassment. They created this slush fund with taxpayer dollars to quiet the accusers. Nondisclosure agreements, if you will. Hush money. We can use the same phrase. They didn't want their constituents to know. Many of them running for re-election as incumbents. They're using tax dollars. It influences the campaign. Why aren't they indicted?
Well, we know why they're not indicted, right? Because we don't want to indict them. But no, it's a good example of things that influence the campaign, and it's worth noting that under the FEC's regulations, if you're an incumbent office holder, you're presumed to be running for re-election. So you're all presumed to be candidates unless they've announced that they're not seeking re-election. So they would be candidates, and this is something that they probably did to influence their future campaign or their perception as office holders. And one thing that's worth adding here, Mark, is because I hear this from people all the time, and even some other, people who know election law, lawyers and some former other commissioners will say, yes, but it was to influence an election. But the FEC in its regulations very specifically rejected the idea that even as to whether it was primarily to influence the election or not, and choosing instead this test that it has to be an obligation that was created for the election. In other words, they didn't want to get into the question of trying to guess, well, did they do this primarily for the election or primarily for personal purposes? And it's very specific about that in the regulations. And I think that's a very important point that people need to keep in mind. And that was done actually to make it more objective and actually to prevent candidates from using their campaign funds for personal use. But, that's the flip side. And I tell people, imagine if you're a lawyer for the Trump campaign and you want to do it all right. You've got one provision of the statute says I have to pay it with campaign funds. Another provision seems to say I can't pay it with campaign funds. Somebody's going to get them coming or going, and that's part of the problem.
So if you're a lawyer for the Trump campaign or the coming Trump campaign, you would do pretty much what Donald Trump did. No campaign money, consult your private lawyer, and they enter into these non-disclosure agreements. Greg, let me ask you this. Isn't the real issue here is people were actually paid under the non-disclosure agreements and then they violated the non-disclosure agreements? I don't see them giving the money back.
Oh, you're absolutely right. I think it's malpractice for the attorney for Stormy Daniels to say, go ahead and talk while the case is pending as to whether or not it's a valid and enforceable non-disclosure agreement. So it's stunning to me. But to Bradley's point, not everything that benefits a candidate is considered to be a campaign expense. Professor Smith wrote that in one of his op-eds, and he's absolutely right. If there is a dual purpose or a secondary purpose, it's not a campaign expense. And moreover, the media rushed and said, oh, Cohen pled guilty, the president must be guilty. That's utter nonsense. First of all, under the Federal Campaign Election Act and other related laws that criminalize violations, there has to be knowledge. You have to show that there was a knowing and deliberate violation of the law in order for it to be criminal. Well, most candidates don't know the election law. Heck, a lot of lawyers don't understand election laws. This gentleman, former commissioner, the Federal Election Commission, chairman, I mean, he knows election law. He may be just about the only one in America who really truly knows it. So you couldn't criminalize what Trump did if it wasn't properly accounted for as an advance or reimbursement. Okay, that's a civil penalty. It's the equivalent of a jaywalking $500 fine, but it's certainly not a crime.
I did a search. It didn't take me long. Of all the federal candidates who've been charged and been convicted of violating these laws, I can't find a single one. Are you aware of a single one?
For this kind of scenario? No, I'm really not. Of course, the most high-profile one would be John Edwards from a few years ago.
And what happened in that case?
Folks may remember that supporters were paying money to a woman, Riley Hunter, I believe was her name, with whom he'd had an affair and an illegitimate child. And now it's worth noting, the U.S. attorney indicted him, so they went to trial on it. So the U.S. attorney thought there was a case. But in the end, the jury did not convict. He was acquitted on some charges, and others was a hung jury. And I think that shows the tremendous difficulty. And, one quick little anecdote when we talk about how obscure this law is, how difficult, is Antonin Scalia, who was, a reasonably good lawyer, right, actually said from the bench in the Supreme Court argument once that this campaign finance law is so complex, I can't figure it out. So if we've got a Supreme Court justice can't figure it out, you see the problems that people have when they're trying to deal with it on a daily basis.
And the reason I'm bringing this up now, weeks and weeks after all the fanfare, is because, and I want to get into this when we come back, this is what happens. It's hit and run. And I want to slow things down so we can unravel things that just happened before we get on to the next thing, which is a daily recitation that wears out the voter, that wears out the American people, of a Trump violation of law, or a Trump ethical violation, or a Trump something or other. And I just feel that this program, we have to slow the process down a little bit and go back and unravel some of what has taken place.